Hello and welcome to the innews series of Drishti IAS. I am Pooja Dwivedi, and in this segment today we are going to discuss about the appointment of Supreme Court judges. This topic is important from the perspective of prelims and also from the perspective of GS mains papers. So let's have a look at the topics of discussion. These are the topics that we are going to discuss step by step, starting with the news. Now, as this news piece has suggested, that the Supreme Court Collegium led by the Chief Justice of India at one stroke have elevated or recommended for elevation 68 judicial members for judgmentship. Now, this is a history, the similar kind of history that was created on the last Tuesday when 9 judges took the oath, and that was the biggest number at one go, 1/3 of them being women. Now, are we actually moving forward towards diversity and to resolve the problem of inadequacy and vacancy created in the judiciary? That is why we are going to talk about this in detail. Let's talk about the judicial system of India. In India, the judiciary is a 3-tier structure. Supreme Court, the apex authority, the last authority for any judicial appeal. The interpreter of the constitution stands on the top. After that comes the high courts, and then comes the subordinate courts. The chapter 6 of part 5 deals with the judiciary in India, and the articles which actually deal with judiciary in terms of organization, independence, jurisdiction as well as powers and procedure of the Supreme Court, that is given in from article 124 to 147. Alright, so these are the certain prelims facts. Moving on, let's talk about how are judges approved of the Supreme Court. According to article 124 clause 2, the President appoints the judges of the Supreme Court, and that comes in consultation with the Chief Justice of India along with other judges of Supreme Court, and is, if the President deems necessary, the judges of the High Court as well. So, for CJI, the Chief Justice of India, the President of India appoints the Chief Justice and other Supreme Court judges. Keep that in mind. And an outgoing Chief Justice of India surely recommends the name of the upcoming Chief Justice of India. For other Supreme Court judges, the proposal is initiated by the Chief Justice of India, and that is done by the consultation with the rest of the Collegium members, which is a 5-member body headed by the Chief Justice of India. We will talk about that as well. Now, after that, the Collegium sends the recommendation to the Law Minister. After that, the Law Minister sends it to the Prime Minister, and then it is recommended by the Prime Minister to the President. So this is the appointment procedure. Let's move forward and talk about the background of it a bit. So if we talk about Article 124 Clause 1, it is given in the Constitution that there shall be a Chief Justice of India of the Supreme Court, and as and when, if the Parliament regulates, or until and unless the Parliament enlarges the number of judges, there should be not more than 7 judges. So in totality, there were 8 judges, including the CJI. After that, in the year 2019, by the legislation of the Parliament, as the Parliament authorized it, the Supreme Court number of judges bill of 2019, it added 4 more judges. So now we have 34 judges, but there is one vacancy. So the judgmentship is of 33 members, including the CJI. Then, if we talk about the appointment of Chief Justice from the year 1950 to 1973, so there was a convention which was developed that the senior most judge of the Supreme Court shall be appointed as the Chief Justice of India. But that changed during the 1970s. What happened? In 1973, A.N. Ray, he was appointed the Chief Justice of India by superseding 3 senior judges. The convention was violated. Again, in the year 1977, NU beg. Okay. So MU Beg was appointed as the CJI, again superseding the senior most judge. So that created an issue because the convention was violated and there was a tussle between the executive and the judiciary. So what happened in the second judge's case? In the second judge's case, this procedure of appointing any other judge rather than the senior most judge was quashed. Okay, keep that in mind. So as I told you, we will talk about the Collegium system. The Supreme Court Collegium system is headed by the Chief Justice of India, which comprises of the 5 senior most judges, and they are there for appointing as well as approving any sort of transfer of the judges. And the system of appointment and transfer of judges, it came through an evolution through the cases in the different courts, not by the legislation of the parliament and not by the constitution. So in the first judge's case of 1981, it was said that there should be the primacy of opinion of the Chief Justice of India. Wherever there is a need for any elevation, the primacy of opinion of the Chief Justice of India should be there. That means unbridled power to the Chief Justice of India. In the second judge's case, which introduced the Collegium system, it said no. If we talk about the powers given to the CJI, it actually means the consultation with the other senior judges means concurrence. That means everybody should agree, and if they are not agreeing, cogent reasons should be provided. In the third judge's case, the Collegium was expanded with the Chief Justice as the head and 4 other senior most judges. Okay, now again a similar tussle was there. The 99th Constitutional Amendment Act of 2015, which created National Judicial Appointment Committee. This was quashed as being unconstitutional because it actually fiddled with the independence of the judiciary. So it was quashed. Moving on, let's talk about the challenges in the Collegium system. The challenges in the Collegium system are such. First, there is opaqueness in the Collegium system. What are the procedures they work through? What is the criteria for the elevation of the judicial members for judgmentship? What are the other criteria which actually approve or disapprove transfers? This is not known yet. Again, another problem with the judiciary. Here we talked about the Collegium system, I am talking about the judiciary. There is a lot of backlog and pendency because if we talk about the provision of judges per million population in India, it is only 20. So that is why as the country is diverse, there will be many disputes as the country is evolving. So we need more judges, at least 50 to 70 judges per million. Again, there is underrepresentation of women and other diverse groups. Women, as we know, the problems with underrepresentation of women is that there could be instances where the judgment needs to be seen from the perspective of a woman when it comes to the community of women. Again, other diverse groups, if there are vulnerabilities to a particular minority, the prism needs to stand from the perspective of the minority judge themselves. So that is something that we need to keep in mind. I as a woman would know more problems of my fellow women other than a male member. They might try to understand, but as I have first hand experienced it, it would be a little different. Okay, so underrepresentation, but there is a way forward. I am going to tell you that a woman belonging to a scheduled tribe from Mizoram has been also recommended for judgeship. So this is also evolving. We are moving in the right direction. Okay, let's move forward and talk about the way forward. First, role of the Chief Justice of India. Now, the Chief Justice of India, this time, by elevating 68 judicial members, again, and if we talk about the last Tuesday when 9 judges took an oath, this role of the Chief Justice of India has shown that the Chief Justice of India is very proactive. He is showing interest in resolving the issues of the backlog and the pendency. And because filling up of vacancies in judiciary is an ongoing process, it's an ongoing process. As the age of retirement for the Supreme Court judges is 65 years, of course, there will be vacancies next year as well because 8 judges will retire next year. So, that is also another problem. So, it's an ongoing process. The CJI should be proactive like Chief Justice of India N.V. Ramana is right now. Similar kind of proactiveness is expected from other judges as well as a precedent. Also, streamlining the appointment system. There is no time limit for the appointment, the filling of vacancies. Okay, so we need for a streamline, for a better purpose, for serving the purpose of resolution of disputes and pendency of cases, we need more stringent limitations. There should be a clause which suggests that up to this date or up to this month, the pendency or the vacancies should be filled up. Again, fair representation of all. Until and unless there is diversity at the topmost places, there won't be a trickle-down benefit of actually tackling with the problems. So that is another, that fair representation should be given so that the diverse amount of cases that come through the way of the Supreme Court, those can be resolved from a better perspective. Okay, let's move forward and look at our mains-based question. Discuss the role of the Chief Justice of India as the paterfamilias of the judicial fraternity and in delivering a sound and timely justice to the citizens and restoring their faith in the judicial system of the country in 250 words. So, that's it for today. Tomorrow we shall meet again with another segment. Until then, stay updated and thank you so much for watching.